Welcome to U.S. Immigration TV. Well, as most people are aware, on January 20, 2025, just as he took office, President Trump issued an executive order that basically reinterprets the 14th Amendment of the U.S. Constitution by stating that certain children born in the U.S. will no longer be considered U.S. citizens at birth. Now, these new non-citizens include, number one, children whose mothers are either out of status or here on temporary non-immigrant visas like student, H-1, visitor visa. And number two, their father is neither a green card holder nor a U.S. citizen. Trump's reasoning is that birthright citizenship under the 14th Amendment requires that the parents and or the child be, and I quote, subject to the jurisdiction of the United States, unquote. Trump's executive order states that the above-referenced children will no longer be considered to be subject to the jurisdiction of the United States and therefore will no longer be U.S. citizens at birth. Now, this is because their mother, who is out of status or here in the U.S. on a temporary non-immigrant visa, still holds allegiance or loyalty to her home country and therefore is not subject to the jurisdiction of the U.S. Now, Trump had hoped to end the practice of women coming to the U.S. for what is called birth tourism, where they enter the U.S., let's say, on a non-immigrant visa, and they give birth to a child who is now a U.S. citizen and entitled to every form of public assistance that they can apply for. Well, currently, there is a preliminary injunction in place temporarily halting Trump's efforts to enforce this executive order, meaning children being born in the U.S. even today are still considered U.S. citizens, subject to the outcome of that case. However, on July 25, 2025, the U.S. Citizenship and Immigration Services, or USCIS, issued what they called an implementation plan, which provides further guidance on how Trump intends to implement this executive order in the event it is permitted to go into effect. In other words, Trump is hoping and looking forward to his interpretation of the 14th Amendment to become the law of the land. And this is because the court, in issuing that preliminary injunction, noted that nothing in this order should be construed as preventing the Trump administration to, and I quote, develop and issue public guidance about the executive's plan to implement the executive order. In other words, the court said it's okay to tell us what you plan to do. In other words, even though there is a preliminary injunction in place now, the Trump administration is already publishing its plans on how it intends to enforce its new birthright citizenship restrictions, as though they are already anticipating being successful once the case reaches the U.S. Supreme Court. And that's where it will have to finally be decided. Whatever's going on in these lower courts or courts of appeal, this is going to go to the Supreme Court. Well, this implementation plan basically defines certain legal terms as found in the initial executive order, such as the meaning of unlawfully present. That's a term set forth in that executive order. So unlawfully present means an alien who has remained in the U.S. after the expiration of the period of stay authorized by the Attorney General or present in the U.S. without being admitted or paroled. In other words, tago ng tago, out of status, or never had any kind of legal status because they snuck across the border. Another term in this implementation plan is lawful but temporary presence in the U.S. So this primarily includes mothers who entered the U.S. on non-immigrant visas, such as tourist visas, working visas, student visas, even though they may still be in valid non-immigrant status. If they give birth in the U.S., the child would not be considered a U.S. citizen unless the father was a citizen or lawful permanent resident. So according to this implementation plan, these children would acquire the derivative status of their parents versus U.S. citizenship. What does that mean? In other words, if a pregnant woman is visiting the U.S. and she gives birth, that child would not be a U.S. citizen under Trump's plan, but instead would be considered a visitor along with the child's mother. Now, to be clear, while the court's injunction is still in place and children born in the U.S. may still be considered U.S. citizens, thank goodness, Trump seems determined to restrict birthright citizenship and will no longer allow mothers to come to the U.S., whether on non-immigrant visas or sneaking across the border and giving birth, many times at taxpayer expense, and then having that child be considered an automatic U.S. citizen, entitling the entire family to taxpayer-funded benefits. Now, I will continue monitoring developments on this issue, and I will report back to you as things arise or there are changes. So therefore, if you are interested in developments in immigration law, tips, advice that you may find helpful, or even this birthright citizenship, please make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.